Hi everybody, welcome to the Finance This Property That podcast. My name is Dion Fernandez and I am a mortgage planner and finance professional. My goal is to empower financial legacies for generations, and I look to do this by using my over 13 years experience in finance and having special guest speakers like financial planners, accountants, buyer's agents, family lawyers who are experts in their field to provide knowledge and free education. And without further ado, let's get into our episode today. Hey everybody, welcome to this episode of Finance This Property That. It is episode 50. Thanks for everyone that's been listening and following along. Appreciate your support. Obviously, if you're not following, please do and tell all your friends about it if you are following. But super special guest, got Natalie Smith from JHK Legal. She was also my first ever podcast guest in episode 1. You can go back into the archives. It's pretty tragic. Was done on an iPhone. But here we are now. Natalie, welcome. Thank you so much.
Thanks for having me. We have come a long way.
We definitely have come a long way from the wired microphones. And although I must say, our background was pretty epic with Storybridge in the back and up in the boardroom. But we're in a awesome studio, much better microphones,
Definitely
better technology. But thanks for coming along. Today, it's actually awesome timing. Not only is it the 50th episode, but there's a massive change happening in Queensland around the contracts when you're buying and selling a property, mainly when you're selling the property, around seller disclosure. Mm-hmm. That's going to kick off August the 1st. Mm-hmm. So I thought we'd get an early couple of weeks out and talk about what is seller disclosure, what's changing, why is this important, and what does it look like? Now, we can't share the new contract. That's the new RERQ contract. However, we will share the seller disclosure document in the links. Natalie's going to talk through some of the key points and pages in the documents. We will flash them up on the screen as we go along, so that you know what we're actually talking about. We're not talking a bit of gobbledygook. But Natalie, what's been happening in your world? And this is a big change. So what's going on?
So from the 1st of August 2025, in about 2 weeks' time, seller disclosure regime will come into effect. So
regime sounds like, wow. Okay, we're talking now.
Yes. So what this means is for sellers who are selling property in Queensland, and it can be residential property or commercial property, this regime will apply to the sale of those lots.
Yep.
So essentially what it is the seller must prepare, and usually via their solicitor, a disclosure statement, and also attach prescribed certificates to that disclosure statement. And basically, in a nutshell, it's a lot of information about the property that is given to a buyer before a buyer signs a contract.
Okay. So does that now stop the real estate agents from creating the contract, or does the disclosure have to be created before the contract's, like, what's the timeline or the process around that?
Yeah.
So if I'm selling my house.
Yeah. So first step is engage your real estate agent, sign your agency appointment form, and then get onto your solicitor straight away to have your solicitor prepare the disclosure statement. Your solicitor will need to order certificates, which will generally be attached to the disclosure statement, and they can take a number of business days. So if you're selling a townhouse or a unit which is in a community title scheme, you'll need a body corporate certificate, and that can take up to around 5 business days, sometimes a bit longer. Sometimes it takes 2 weeks. You're waiting on the body corporate to prepare that for you and give you the certificate and the information that's contained therein. So ideally, you want to get onto your solicitor straight away to get this document prepared on the basis that you're intending to sell straight away. So basically it's ready to go once you've found a buyer. The agent can still prepare the contract, and then we would review the contract before it's signed. or you can engage your solicitor to prepare the contract as well. So it might be preferable to have your solicitor prepare the contract in circumstances where there are matters that you do need to disclose, because you might need some additional special conditions to deal with those disclosure obligations.
Oh, interesting. So technically you cannot sign a contract till the seller disclosure is done and handed over, and
Correct.
it's all in the pack, and then the agent can potentially
You can sign a contract, but you shouldn't.
You definitely can do it, yeah.
But you shouldn't, because if you do not provide a buyer with a signed disclosure statement that is complete with all the prescribed certificates, a buyer can terminate that contract at any time up to the settlement date. So it's really risky if you don't get this right.
Just get it done right the first time.
Exactly.
If you're serious about selling, follow the rules. We don't have any issues.
That's right.
Cool. So, seller disclosure. Now, what does it actually cover? So, what do they actually have to disclose versus the stuff that they don't have to disclose? I think that's real. I think that's where I feel that there's a bit of a lack of information around.
Yeah. All right. So we'll have a look at page 1 of the seller disclosure form. It's called a Form 2, and you can access it online. So on the first page, it talks about some information that is not included in the disclosure statement. So a seller doesn't need to disclose about flooding or any other natural hazard history. They don't need to disclose about the structural soundness of the building or any pest infestation. So that's where your building and pest condition in a contract still comes into play and is really important. They also don't need to disclose information about current or past building or development approvals for the property. So let's say, for example, the seller did a renovation, they built a deck, added on, another room or something like that, and they did that without building approval. That's not a matter that they would disclose under the contract.
Okay.
So they also don't need to disclose information about the presence of asbestos within the building either. So there's other things that aren't covered
Those
here,
are the key
but
ones.
they're sort of the key ones that a buyer will want to know, and will need to do their own due diligence around still.
Okay. So what are they disclosing then?
Yep. So let's look at what is included. So we need to provide the title particulars, which is fine. We need to give a buyer a copy of the title search, a copy of the registered plan for the premises. So this is the actual surveyed plan that is lodged with the titles office, so you can see the boundaries.
Because you don't normally get, in the current contracts, you don't get that.
No, you don't.
I know, I've just signed a contract. I got the title search.
Yes.
But I didn't get the lot.
And that's
the lot.
basically it.
Yeah, right,
Really.
okay.
So you'll get both of those documents. A seller then needs to disclose any unregistered encumbrances. So, for example, a residential tenancy agreement, that would be unregistered on title. That needs to be disclosed. And you need to give particulars about that, which is in the contract in any event. But there could be other unregistered encumbrances. So let's say, for example, there's a Brisbane City Council pipe or something like that that is running to the rear of your property. You need to disclose the location and give a description of that utility infrastructure. And you also need to attach a copy of a plan, which is showing the location. So this is where a dial before you dig search comes into play, where we'll look to see if there is any of that infrastructure or anything like that running through your property, because there's an obligation to disclose that.
I think we had that conversation just the other day talking about what are these unregistered encumbrances, because they're not obviously disclosed, but it's ticked in the current contract. So my contract is pre-August 1st. It's just been ticked. I don't even know what it is. And Jana brought up going, hey, hang on, what are all these?
It's usually always ticked yes, because a lot of the time the seller doesn't know. Like they don't know that I've got, a pipe running through the backyard, or because you can't see it, or they don't know that there's a right of way for, a utility provider like QUU or the council to access the property to maintain that, infrastructure. So usually when contracts are prepared at the moment, it's just a catch-all clause. Yes, the contract could be subject to encumbrances that we don't know about, and it covers all of those things.
Okay, cool.
So also other unregistered encumbrances can include things like mortgages. So let's say, for example, you have an oral agreement with your mum who you borrowed some money from, for example, and you effectively, maybe you signed an agreement, but you didn't register it on title. That's something that you might need to disclose as part of the disclosure as well.
Interesting.
Because it's an encumbrance that affects the property.
So she could come back and have it say, I've got a stake in the property, you can't sell the property.
Yeah, that's right. Yeah. And then the next section is around land use, planning and environmental matters. So we need to tell a buyer about the zoning of the property. Generally that's just covered under the local government city plan, for example, that information. If there's any proposals by Transport Authority to resume part of the property or the land. For example, if they want to widen the road for infrastructure purposes or something like that, if you've got a copy of that notice or proposal, you need to attach it and give notice of that to the buyer. And then if the property is contaminated or it's on one of the registers, which is the Contaminated Land Register and the Environmental Management Register, then you'll need to give copies of those documents and notices. It's generally not applicable for residential. Most residential properties
most of the
won't
locations.
be, unless, I don't know, they're next to a service station or there's some, there's seller would generally know.
Last night on the news, the places in Burpengary on either side of the highway are potentially going to be, houses are going to have to be resumed to make the highway wider and things like that.
Exactly.
So...
Yeah, so that's an example. If you've got a notice to say we're resuming part of your land, you need to disclose that to a buyer. Whereas prior to the introduction of this regime, a seller would make warranties about that. They would say, to the best of our knowledge, this property is not affected by a plan to resume. And it's up to the buyer to find out whether that warranty is true or it's false. Whereas now the obligation's on the seller to actually provide copies of the notices.
Yeah.
You'll need to provide copies of any orders or applications through QCAT if there's disputes around trees between your neighbour.
Trees, right. Yep.
Whether the property is heritage listed, but flooding doesn't come into play. So you don't need to give any information about flooding.
But this is what baffles me about this thing. So you've just told us all the stuff that is not included, but it's all that's actually the most important. Some of the most important things.
Some of them are.
Why have they not? I mean, from your understanding, why have they just not included it all? Like, what do you think the reasoning behind it is?
I think a buyer can easily find out the information about flooding, but notices to resume and some of those matters are not always discernible by search. And I'd say, for example, with unregistered encumbrances and statutory encumbrances and things like that, it could really affect how the buyer is to use the property in the future. It can affect the value of the land. If you've got a plan to resume, well,
yeah, true.
They're big matters that are really going to affect.
So I just had a bit of a thing here because it's not putting it all on the seller to do their due diligence. It's also putting things for the buyer to do their due diligence and making sure that they're checking off the things that aren't on here. So that's their responsibility versus this is what the seller disclosure is.
Yes.
They have to give you all these ones that really are probably harder to find. I was just going to say, would you be able to do a search to find if the
I
land's
mean,
been
most of
used
these
up.
things you can search. It's just a lot of people don't know how to search, or where to find the information. So
That's why you need a good solicitor.
yeah. And then the next section is around the building and the structures. So if there's a pool, you need to provide the pool safety certificate or notice that you haven't provided a pool safety certificate. Whether there's an owner-builder permit over the property as well, you need to provide a copy. And then also if there's any, for example, show cause notices or enforcement notices under the Building Act or the Planning Act. So, for example, maybe there was unauthorised building work, the council are aware of it, they've issued you a notice to either get the approval, or if the building work was defective, for example, you need to demolish it, start again, or rectify it. So if there's any of these notices about work to be done on the property or offences under the Planning Act, you need to provide copies of those notices.
So so let's say they don't provide those copies, but they have been issued, and then the settlement's happened. What happens then?
So you have a termination right if these notices are not given, but that termination right ends when settlement's affected. So you effectively lose any rights that you have. So it's important for a buyer to still be doing their due diligence and engaging their solicitor to do a council search of the council records, for example, because if the seller's just selected no, these notices don't exist, well, there's no way to prove that that information is true or correct unless you do the council search and you verify it that way.
Yeah.
So it's still recommended for a buyer that they're still doing their due diligence.
Yeah. So you'll have a set of recommended searches that you do now, and it would probably be basically, logically, it'd be going, well, the seller has to disclose this, but we need to do the searches on this. Basically, if the house has been majorly and structurally renovated, you should be doing the extra searches anyway now as of August. Well, you should be doing it anyway. Yeah,
and I mean, it's a decision for the buyer. Sometimes they're already aware that, for example, this, they've built underneath the garage area and it's not legal height, can't be occupied as a residence or a bedroom or anything like that. But they're aware of that because the agent's disclosed to them, or the seller's disclosed to them in some way. And maybe the buyer takes that risk. It's up to the buyer. If maybe they don't care that there's unapproved structures on the land, but it's always it's dependent on the buyer, but we do recommend the searches.
Well, if their median house price is close to $1 million or $1 million or over, it's a big investment.
It is a big investment.
What's an extra couple $100 for the search?
Exactly. The search is less than $400.
Yeah. And also the cost versus the cost of fixing it yourself,
which could be huge.
Yeah, in the hundreds of thousands.
Exactly.
On top of the $1 million that you've already paid for the property.
Exactly.
So just be organised, get it done.
Yeah.
Yep. What else have we got?
So we need to give information about rates and water. So how much is a buyer up for in terms of paying for utilities?
Yep.
And then if your property is within a community title scheme, you'll need to provide a copy of the CMS. So the CMS document contains all your bylaw information and any exclusive use areas. So let's say you get a car park or a courtyard or something like that. And then we need to attach a body corporate certificate. So that gives information about levies and financial information. But you don't need to attach copies of minutes from the meetings held by the body corporate. So what this means is if we're acting for a buyer, we would still recommend an inspection of the body corporate records so that we can find out what's happening within the body corporate. We want to know if there's any major sort of like maintenance issues or anything like that where they're going to raise special levies and then on-charge them to the buyer. When we want to know if there's any defects in common property and things like that, or just if there's disharmony within the body corporate, if there's disputes and things like that, you want to know what you're buying into. So there still is some due diligence that buyers need to do, notwithstanding the certificate and the CMS being provided. And that's basically it with the disclosure.
Okay. Wow. There's a lot.
There's a lot.
Yeah. And I think it's about making sure you find the right, because I think you can very easily skim through that and just get tick, 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 and not, from a seller, and then the buyer's picking it up just going, oh yeah, I'm just going to believe what the seller's told me. It's kind of like what it is now. We're just signing a contract and believing that this is the property that we're getting, and you just got to figure out, look and search underneath everything anyway, and do the right searches. You don't have to do every single search, but like I think the right searches and based on the advice that you're paying for, get it done.
Yeah.
Get it done.
Yeah.
So is that now going to change? So we've got the disclosure statement. That's got to be handed with all the certificates and all the information, along with the contract for sale. Has this new regime, that's a weird word to say, but has that now prompted a change in the actual contract of sale? Okay, cool.
So there'll be new REIQ contracts, which will be issued and will come into effect from the 1st of August. There's a few changes in the contract, not too many. I will just bring up a copy of the contract. So
let's go through a couple of those. I mean, we've got the basic, like page 1 is,
Exactly.
Yeah.
So page 1 is just seller details, the agent, the seller solicitor, fine, standard. On page 2, you have the buyer's details, description of the property, and then you'll have a section here for the deposit. So the format's a little bit different, but the information is more or less the same here. Here you'll put your purchase price. And on the topic of deposit, you've got an initial deposit and a balance deposit. So generally what we recommend is you pay, if you're a buyer, you pay a smaller initial deposit. Maybe it's $1,000 within 2 business days from signing the contract. And then once you go unconditional, so after you've satisfied your finance and you're building in Pest or your due diligence, then you'll pay more or less 5% of the purchase price, or however much you can negotiate. For a buyer, you want that to be as low as possible. For a seller, you want it to be as high as possible.
Yeah. Is that do you have to?
No.
Because I feel, look, I know we're going to digress a little bit here, is I've seen contracts have like $1,000 and then you got to pay like $100,000. Now, if we're doing a full debt restructure and strategy, we're pulling equity out of other properties that's not going to settle. They're either going to settle the same day because we're pulling equity out, or they just won't settle, and like we'll get the approval before the settlement of the restructure.
Yeah.
So what, I mean.
Yeah. So generally the deposits need to be paid in cash and then transferred to the seller's solicitor's trust account or the agent's trust account.
Yeah.
It's really what you can negotiate. There's no rule. It doesn't need to be 5% or 10% of the purchase price. It can be $10,000, for example, as a balance deposit. It's just what the seller will accept. So if you explain your circumstances, let's say you're selling your principal place of residence and buying another property, and your deposit and your equity is all tied up in your existing property, you don't actually have the physical cash, you can explain those circumstances and say, well, I'm only paying, a $5,000 deposit today because all my equity's, in my property, and that's the circumstances.
Yeah.
So it's just by negotiation.
Yeah. Okay, cool. So it's not a hard and fast stuff. The real estate agents are sort of pressuring you to do it. Just figure out, again, come back and speak to your broker and figure out when funds can be released.
Yes.
And we can come up with that strategy as well. Sorry, I just wanted to, just clear up, I think, because there's a bit of a misconception that you have to pay all these deposits up front and things like that. But really, it just sits in the real estate account.
It does until settlement.
And that way they know they're going to get paid, basically.
Exactly. They know that their commission's covered.
Yeah.
And then on page 3, you've got your settlement date. You've got a section here to talk about GST and withholding obligations. And that usually is more or less if you're buying from a developer, for example, and you need to withhold to cover their GST liability at settlement.
Okay.
Most, if it's just a normal transaction, without exactly, it's generally not applicable. There is a new section about land tax. So
okay, yeah, let's go on that. Yep.
So prior version or current version of the REIQ, there's no ability to do a land tax adjustment unless you have a special condition to that effect. But this gives the option, so for an investor, for example, that pays land tax and it's not their principal place of residence, you can have the buyer contribute to that, the cost of that land tax at settlement, and be doing an adjustment. And it can be on the actual land tax liability, or it can just be based on as if this property was your only property, and you're a natural person. So, that's a big change.
Let's unpack that. What is that like? Let's do a scenario, because all that stuff's really good. So let's do a scenario where let's talk us through that. So what does this look like?
So let's say, for example, the seller's actual land tax liability is $15,000. For example, this is just an example. And that's the liability that applies as of 30th of June at midnight for that year. And that's the tax year. So it'll be from then, the 1st of July until the next 30th of June. So let's say settlement happens in December, halfway through the land tax year, and the seller has ticked, we're going to adjust based on the seller's actual land tax liability. Well, then you'd be up for half of that land tax liability. So that's $7,500.
Me as the buyer would be up for half, even though it's my owner-occupied place.
Exactly. So the seller's asking for an adjustment in their favour to cover a portion of their land tax liability, which doesn't ordinarily happen now.
No. So if you're purchasing, and you just said something about being a real person. So if that's like, if you're purchasing off someone's company trust structure,
it's going to be higher. The land tax is going to be higher.
Yeah, right.
Yeah.
Okay.
So we can do a search for you before you sign a contract. Usually comes back very quickly to find out what is the land tax liability. And if it's nil, great. Not applicable, doesn't matter anyway. If it's $1,500 and the seller wants you to pay a portion, you might say, okay, it's only $750. That I'm going to be liable for here maybe. But if it's a large land tax liability, you as a buyer don't want to be having to pay that at settlement or contributing towards that. So
yeah, interesting. So just before you sign a contract, read what you're signing and get it checked.
Yes.
Before the contract. Don't be pressured into signing a contract that you don't understand.
100%.
Yeah, that's wild.
Yeah.
Because that's going to cause a few issues with people trying to sell their properties now.
Yeah. I mean, it is the case in, I guess, New South Wales at the moment where you can adjust for land tax. But yeah, it'll be interesting.
I wonder if they're going to adjust the price. If you're making me pay 15 grand. Yeah. Well, that'd be interesting. It'll be interesting to see, I think, when we have you on next to talk about some cases that have come up.
Yeah, we'll see what the contracts look like. There is, of course, a box which you can tick which says no adjustment is to be made for land tax. So as a buyer, you always want that one ticked.
Yeah. Please read the contract.
Yes. And then on page 3, you also have your finance clause and your building and pest inspection date. So with the finance section, there's 3 components. You've got the finance amount, so how much you're borrowing, your financier, who you're borrowing from, and then your finance date. So that might be 7 days from the contract date, 14 days from the contract date. You just be guided by your broker as to how long you need. It's important that every single section is filled out or finance will not be applicable. So sometimes we see contracts prepared by agents that just say a finance date only, and that might be 7 days from the contract date, but they haven't completed the finance amount or the financier. And in those circumstances, this contract is not subject to finance. So a buyer can't terminate
Yeah.
if they can't get finance.
Yeah, and that was picked up on my one, that it didn't have the information on there, and it was changed. Like it was just, I think it was just done up very quickly, and it was changed, and they just put finance amount sufficient to complete, and then financier buyer's choice. Yeah. So if they're on there and it's got, then it obviously had 7-day finance.
Yeah, as long as you've got all three filled out, that's fine.
Yep.
And then you've got your building and pest inspection date. So it's important that for a buyer you still do a building and pest, because the seller disclosure statement, there's a section there which warns a buyer this disclosure does not discuss building and pest issues or structural soundness of the building. So the buyer still needs to have that inspection done to make sure that there's no structural issues or a major pest infestation with the property. And then on page 4, you'll need to disclose your title encumbrances. So, for example, if there's a registered easement or a covenant or something like that. And then there's a tenancy section. So this all looks fairly similar to the previous version. And then they've actually combined usually you would have a separate contract for a house compared to a lot within a body corporate scheme, whereas they've combined it in just to one contract now.
Oh, that's good.
Yeah, it is good. So it's just residential or commercial, and that's it. You just pick one or the other. And so in this new contract, there's information here to complete for a body corporate, and then you've just got your signature pages. So there's a few changes in the reference schedule. There's a few amendments to the standard terms as well. There's one interesting one about extending the settlement date through PEXA.
Yep.
Or electronic settlement, for example.
Because at the moment you can extend it by 5 days without approval.
Correct, yeah. So either party can extend for a period of up to 5 business days, and you just need to give notice. But one thing to watch out is that, let's say you're the seller and you've already used up 2 days, that only gives the buyer 3 more days. You both don't get 5 business days each. It's just either party can extend for 5 business days.
Total between the two of you.
Exactly. Yeah, but there is a provision here that if someone signed off in the PEXA workspace, which is how we conduct settlements these days, and someone has signed, something is done in the workspace, someone's changed a financial piece or something like that, and it's been that will make it so that settlement won't go through, and that happens between 3 o'clock and 4 o'clock in the afternoon, because in Queensland 4 o'clock's the deadline for settlement to go through. You get a 24-hour extension, so it's just covering like a technical sort of aspect. Yeah. But for the most part, the standard terms are pretty similar.
8.1 still there, where you have to have the bloody insurance on it by 1 business day.
Yes.
Why? I don't know. Queensland's the only state that requires that.
Yeah. Well, you don't have to take out insurance, but the property's at your risk from 5 p.m. the next business day after you sign it. Yeah. So, you want to be protected. You want to have public liability insurance. You want to have building insurance. You just want to, it's at your risk. So
don't rely on the person.
No, but you get a cover note.
Yeah. I know you can. It's just weird that Queensland's the only state that does it. And because I do lending in other states, and I'm like, oh, don't forget your insurance. I'm like, oh, hang on, no, you're not in Queensland. You don't need it.
Yeah.
But just check anyway. Just check with your solicitor whether you need it or not. So, because the client's in New South Wales, and I just go on autopilot. Yeah, you get it. They go, oh, it's a unit. I'm like, oh yeah, just make sure you still need. I said no, because I still need the certificate of currency when I do the settlement.
Yeah.
So I said, just get me the certificate of currency from the body corporate. Oh yeah, okay, cool. But I'd still make sure that you're getting contents insurance, because you've got all that legal liability and stuff like that inside it.
That's it.
Cool. Any other major changes? Or that's pretty much it, isn't it?
Oh, in terms of the seller disclosure, I mean, it's a big change. But we're really prepared, because we act for buyers across many jurisdictions, and disclosure is already implemented in Victoria, New South Wales, other states. So we're used to preparing disclosure statements and that kind of process.
So this is just like Queensland catching up to digital mortgages. Yeah,
exactly.
Right. Yeah, cool. You also touched just briefly that this also extends to commercial properties.
Yes.
Has the we don't have it here, but has the contract for commercial properties changed slightly?
Yeah.
Very similar?
Similar, yeah.
Yeah.
So there's slight variations there too.
Yeah. So if you are selling a commercial or residential property and the contract is live from the 1st of August onwards, please make sure that you've got the right contract. That's the one key takeaway. 2, just because there's seller disclosure does not stop the buyer's due diligence. Do your due diligence. Don't just take the seller's word for it, because the seller disclosure doesn't cover everything. And 3 is, if you're the seller or the buyer, and we've said this right from our first episode, be organised. If you know you're going to sell your property, get the documents going, engage a real estate agent while that's all going, and because they're going to ask you anyway. So just get it done.
Yep.
And that way, there's no, it runs smoother. You'll be able to sell your property, buyers will be able to buy the property, smooth settlement, we move on.
Yeah, you don't want to have a situation where you found the right buyer and you're ready to go, but you haven't completed your disclosure, and then you need to wait for certificates and searches to come back to complete it. So,
and it could take up to a week for all that to happen, depending on the type you've got to get. So just be organised. I think that's the biggest thing. Don't do things in a rush and go from there. What else? Anything else exciting? That's about it, isn't it? Sweet. Well, thanks so much for episode 50. Appreciate you coming on, being right there from the beginning. The information on this podcast is general in nature. Doesn't take into consideration your personal circumstances. If you are thinking about selling a property in the next, after July 31st, make sure you've got the right information. You're engaging the right people. Natalie and her team from JHK Legal, very easy to find. How do we find you?
You can find us on the website, JHK Legal. You can send me an email. My surname's changed. So it's, it's natalie.pearson@jhklegal.com.au.
Okay, cool. Or just look up jhklegal.com.au and they'll find them. There's only one Natalie, I think, in there anyway.
There's only one Natalie.
There's only one Natalie. And if you do want to talk about your options, give us a yell, and your personal circumstances, give each of us a yell on what you want to do. But again, you can find me at Dion Finance Specialist on Instagram, Dion Fernandez on LinkedIn, and the podcast website, www.financethispropertythat.com.au, where you can actually go back and look at all the back episodes. The first episode's not actually on there. That's actually on my Instagram and YouTube channel. So if you really want to see what their first ever episode looked like, jump on those two. Make sure you follow, though, because that's the only caveat. But, mate, thanks for your time. Appreciate you being here. And the documents, we can't give you the contract of sale, but we'll try and post the seller disclosure in the show notes, and we'll show some snippets of what we've talked about. Thanks again. See you on the next episode.